Recently, we came across a tip that would appear to be an alternate suspect.
And they can't identify it. That's what you call a real burner, folks. That's Slocum. You can't tell me that his phone went off the radar 6 days earlier. You've never seen his phone pop back up, but all of a sudden now you see a burner phone that they can't track and you don't think it's Slocum? Come on now. He left in Los Angeles, went straight to Moscow, handled business, and then they met right back up in Ellensburg, right in the middle of Seattle and Spokane, exactly where you would expect them to meet. The devil is always in the details. That proves who the assailant was at the King Road residence on November 13th, and that is your alternate suspect. You can take that track phone number defense, run it with the 3,800 cell phones that were on the cell tower, and I bet you $1,000 that one will pop up. There you go.
And we're trying to work through that as rapidly as we can. It was quite a surprise to come up with that.
Like you, be strong to hold the powers of the sun.
I show you how deep the rabbit hole goes.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And in this episode, we're going to get into the one that a lot of us have been waiting on, and that is the alternate perpetrators and the alternate perpetrator evidence. So we're going to break down the rather short segment of the motions in limine hearing about the alternate perpetrators, but there was a couple other parts of that hearing that did touch on this as well. So we'll go over those also. But when we talk about the alternate perpetrators, I'm going to break this one down for you because there's some things that you have to understand as it relates to this topic. It's not so cut and dry. And one of the things that we heard Ann Taylor mention, not during the alternate perpetrator segment, but during the segment about the experts, was what the defense's expert is going to testify to.
Didn't you produce an expert who said that that it would have required two people to commit the crime?
Your Honor, we have produced an expert that believes that it's likely that there were two people, two weapons.
Now, you may be asking yourself, well, why would the fact that their expert is going to testify that there were two perpetrators with two different weapons, why would that correlate to what we're discussing here with what the defense is going to present in the form of evidence of an alternate perpetrator? How do the two go hand in hand? And it's real simple.
That we are calculated and thoughtful in everything that we're doing in this case, and we wouldn't treat alternate perpetrator any other way.
So with the defense saying, look, we're going to be calculated when it comes to alternate perpetrators, just like we have been on everything else in this case, well, you're going to have to understand this at this point, because this is where old Pob's investigation is going to leave all the naysayers out there in the dust when it comes to trial. Because what did they just say? Their expert is going to testify that there were at least two perpetrators with two different unaliving weapons. So when they're talking about bringing forth alternate perpetrators and the alternate perpetrator evidence, do you think they're going to just bring one person? Not if they're being calculated, because their expert says there's two. So that means when they bring forth alternate perpetrator evidence, it's going to be for two individuals, not one. And guess what that opens the door for as soon as they do that? And this is going to be the defense's case. And it has been all along. Because what does two perpetrators automatically mean? You see, as soon as you bring in two perpetrators, then you have to go to the law definition of conspiracy. In law, conspiracy typically refers to an agreement between two or more people to commit a crime or illegal act where the illegal act doesn't have to be fully carried out for the conspiracy itself to be a crime, the agreement and the intent to commit the underlying crime are the key elements. So 2 or more individuals involved equals conspiracy. Now, this is where the whole world needs to come to the proper conclusions. You see, for the defense to put on a 2-perpetrator defense, which will lead to conspiracy, well, you've got to understand that eliminates a jealous ex-boyfriend. Because while it would be an obvious alternate perpetrator, once you add the other person to the element and a conspiracy exists, then it would be way too difficult to prove. Then you eliminate the frat boy fight at the frat house, because once you add the element of another perpetrator, a conspiracy would be too difficult to prove. Now you have to go to all of the real evidence that everybody has ignored since the beginning of the case. And here is the real evidence. The first thing law enforcement stated when these crimes happened is this was a targeted attack. A targeted attack. Now, remember what was targeted. Was it the people? Was it the house? Or was it specific rooms in the house that contained specific people? You see, when you look at this house and there's 5 different residents on 3 different floors and 6 possible bedrooms, yet only 2 of the rooms in the home contained victims. Well, targeted is easily determined by the 2 rooms in the home, therefore the 2 residents of those 2 rooms. And is it a coincidence that their parents just happened to have been involved in illegal activities right leading up to this incident? Now, I've gone through great links to show you the connections between those parents and Farley and what happened in that situation, those parents and those very dangerous group of individuals known as the Aryan prison gangs, and what happened in that situation. And soon I will be bringing you a video that will bring it all together and show you that it's a lot more than just a theory. But in this one, we're focused on the alternative perpetrator evidence that the defense will be bringing forward. So something you have to understand, though, as soon as the defense brings up that it's 2 perpetrators, 2 different weapons, then you have the conspiracy, but then you also can see the picture that the defense will be painting throughout this case that the prosecution can't. And I believe it will go a long way to annihilating the state's case, because it will address the single most important issue in this case, which is the motive. And guess what the prosecution's motive for this case is? And guess what 2 perpetrators eliminate entirely? Their motive. Now let's listen to that segment of the hearing and we'll break it down and see what kind of insight we can get from the defense's strategy and what they're going to have to do to get that alternative perpetrator evidence included into this case.
All right, that leaves in category A by my score sheet the alternative perpetrator evidence, which is the state's motion to eliminate.
It's the state's motion. Do you want to sit here? Oh, I didn't see that one. Why did he stick that one in there?
I just forgot it. Thank you, Your Honor. And this is actually a very convenient transition We're looking at the history of this case and investigation. Of course, the investigators and the state went probably some 6 weeks following the homicides, and during that time received thousands of tips and tried to substantiate or discount whichever we could. Where we ended up is the investigators were unable to substantiate any tips until they received the tip regarding Mr. Kohberger itself. The state's concern in bringing this particular motion is that the defendant is going to try to offer alternative perpetrator evidence based on what we would call mere inferences that another person could have committed the crime, and the case law in Idaho says they clearly can't do that.
For purposes of your motion, are you talking about the defense's allegations of specific individuals? I mean, obviously, the defense claims the defendant didn't do this,
Yes.
which would suggest that there was an alternative perpetrator.
Yes. And the state's concern is about the defense focusing on specific individuals without meeting a threshold showing of connecting that individual to the homicides itself. And the state's concern is about the defense focusing on specific individuals without meeting a threshold showing of connecting that individual to the homicides itself.
Now, one thing I did notice after, watching these hearings over and over and over several times now, and I know everybody out there probably noticed how nervous that Bill Thompson sounded as he argued a couple of these motions. Now, sometimes he would get up there and he didn't sound nervous at all and he presented just fine. But other times, this one in particular, he just sounded a little bit too nervous. And it wasn't just the crackling in his voice and, misstating words that shows his nervousness, but it's also in the fact that his arguments aren't consistent within the same motion. As you just heard him say right there, the state is concerned that the defense is going to focus on specific individuals without showing first a connection. So if that's the state's concern, that the defense is going to focus on specific individuals, well, then why does he make the next statement that contradicts that entirely?
And our concerns actually are reinforced by the defendant's response to our motion. When we're looking at pages 2 and 3, at the bottom of the page, the defendant says, "This case is full of alternative perpetrators. There are many alternative perpetrators." That suggests to us that the defendant is going to shotgun any variety of people's names, and we think that they can't do that without making the threshold connection first.
Now, which is it, Bill? Is the state worried that the defense is going to focus on specific individuals, or is the state worried that the defense is going to go with a shotgun approach and imply that many other people could have done this? You see, he's making two different arguments within a matter of seconds. So that shows his nervousness on this subject. And he's trying to get the judge to lock down some things for him. And what he really wants to know is what is the defense's evidence of alternative perpetrators. And he's very nervous about it, as well he should be.
Based on the case law, based on rules of evidence 401, 402, and 403, State versus Meister is the most applicable case. State versus Meister is the most applicable case. We're seeking an order prohibiting the defendant from offering specific alternative perpetrator evidence without first having an offer of proof to the court that specifically connects this third party, this alternative perpetrator, to the crimes themselves. And then we would also ask that the court set a reasonable deadline for the defendant to give the state and the court notice, make their offers of proof so we don't have to encounter this in the midst of trial, that we can prepare adequately for it. So that's the nature of the state's motion, Your Honor. Thank you.
That's all.
Your Honor, we do, as the state indicated, plan on providing offers of proof regarding alternate perpetrators. There's nothing about our approach that would be a shotgun approach, throw a bunch of spaghetti at the wall and see what falls. We understand that It requires the conditions of Meister, and it requires the conditions of Meister, and that we need to provide that information to you.
Now, let me ask y'all, do you think it's just a coincidence that I put so much emphasis on State versus Meister a few weeks ago, and now we see in the most critical motion of this entire case, the alternative perpetrators, everything hinges on the rules of Meister? Is that just a coincidence? Or I'll let you decide. But what do they mean when Meister is the rules as it relates to alternative perpetrators in Idaho? And it's rules 401, 402, and 403, but they're governed by the case State versus Meister. Should say Bill Thompson versus Meister. Let's look at the rules of Meister. So the rules of Meister are really clear. It says you must take into account the Idaho Rules of Evidence 401, 402, and 403 with one other little caveat. And the Idaho Rules of Evidence 401 is a test for relevant evidence. Evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. Now, Idaho Rules of Evidence 402 is general admissibility of relevant evidence. Relevant evidence is admissible unless these rules or other rules applicable in the courts of this state provide otherwise. Irrelevant evidence is not admissible. So really, this is the one that pertains the most to Meister. Relevant evidence is admissible unless these rules or other rules applicable in the courts of this state provide otherwise. That's where you go to the other rules that are applicable because of Meister. And then 403, excluding relevant evidence for prejudice, confusion, waste of time, or other reasons. This court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. This is what Thompson is hoping for. This is what the defense is hoping for. So let's go to the ruling party, which is the Meister rules, and it's real simple what the Meister rules says. It says, we hold that the corroboration requirement found in IRE 804B3 is satisfied if the district court determines that the evidence in the record corroborating and contradicting the declarant's statement would permit a reasonable person to believe that the statement could be true. So all the defense has to do is provide enough evidence to where a reasonable person would believe that the statement could be true. Not that it is true, just that it could be true. So the rules of evidence are actually very weak as it relates to what's required to introduce an alternative perpetrator.
We are still in the process of doing investigation, as you know, with the amount of evidence in this case, and there's been a lot of briefing. There's going to be a motion argued about that. We are working as quickly as we can to put pieces together that make sense under the terms of Meister to present to you for that consideration with an offer of proof. So we understand the obligations. We won't be taking a shotgun approach. I would hope that the court would see that we are calculated and thoughtful in everything that we're doing in this case, and we wouldn't treat alternate perpetrator any other way.
Now, if the defense didn't have anything, they would be screaming for more time to come up with an alternative perpetrator. But that's not what she said. She said, we will provide an offer of proof, but there's a ton more discovery, and we really want to, have everything together when we do that. So basically what the defense is saying is, we got you, but we don't want to give it to them 1 second before when we have to give it to them, because we want to give them the least amount of time for them to try to go in and create some BS to try to debunk it. But you can bet at this point they have plenty, because folks, all they need is I see you Farley to put Farley at the scene of the crime. And I just gave them the burner phone number for Slocum. If he's in that 3,800 people, he shouldn't have been in that area. If he is, that's all they need. But then again, they've also got the blood on the handrail and the blood in the glove that nobody seems to be bringing up. There's plenty of ways that they'll be able to tie their alternative perpetrators to the scene of this crime.
I don't believe the state has anything further on that point.
All right. I think the parties are both correct in that State v. Meister is controlling here, where the court has spelled out that if the defense intends to present specific alternate perpetrator evidence, they have to make a factual showing that would, in fact, connect such a person, rather than just throwing names out or arguments or theories out without evidence to support that. I don't want to do that at trial. I think that's not enough time for the state then to investigate that. And I don't think it's enough time for the court to respond to that. And I think we'll waste a lot of time where we are not having trial as a result. And so what I would like to do is to look at a date shortly around the time of the pretrial to hear those proffers and go from there.
Now that right there is where everybody's getting that the hearing's going to happen on May 15th, because that's when the pretrial conference is scheduled. But I believe the judge's next statement gives a little bit too much leeway for that. And since there hasn't been an actual scheduling order for that to happen on May 15th, I firmly believe the defense is going to try to push it off for as far as they possibly can. So I wouldn't bank on May 15th being the deadline for this thing.
Now, things may, I'm not discounting the fact that things may unexpectedly happen after that, but in terms of what we are or should be aware of at this point, I think we need to flesh that out before we go down that road. And so I will probably reach out with your calendars and set a date sometime around that pretrial, maybe even during that pretrial, since you're here to take care of that.
Thank you, Your Honor.
Let me tell you, folks, you see this right here, after that hearing, everything that I heard from everybody, and I've watched it several times now, it not only makes me understand that, this thing is not a slam dunk for the state. I don't see any way, honestly, that the state will be able to win this case. And let me tell you why. Because the state doesn't have a motive. But what they're going to try to do, it's very apparent with their evidence, is they're going to try to use things like BK's turn paper on crime scenes, his Reddit survey on criminals, depraved Google searches, the fact that he had possibly purchased some different items well in advance of the crime. They're going to try to let this type of stuff imply the motive. And when you imply the motive, the only thing that you can imply is like I showed you in this episode, and that's Ted Bundy or incel. And once the defense hammers home alternate perpetrators and the fact that there is more than one suspect that committed the crime, then that takes the prosecution's motive and throws it in the toilet. And then you go to the real evidence in the case, the surveilling, the 7 minutes. Everything that I've seen in that hearing lets me know that the state is going to fail and fail miserably when it comes to this piece of actual evidence. It won't fly. The car, based on exactly what Ann Taylor said, she said, and she reaffirmed it, that vehicle on Ridge Road is identified by the FBI as an 11 to 13. He did not change his identification until he got pictures of video of Kohberger's car returning to his house on WSU campus the next morning, that's when he changed the year model. They're sticking with that. I bet you they have a vehicle identification specialist that could absolutely testify that the vehicle on Ridge Road was a 2011 to 13. This one isn't going to fly. This eyewitness testimony, I promise you, she wasn't even there. They're going to know that. They're going to discredit that in a major way. And once they do, then this means nothing as well. So the state by itself will not be pointing to the defense to explain why Kohberger's DNA is on a knife sheath. The state is going to be left trying to explain how Bryan's DNA could have been on a knife sheath if he wasn't there. That's what it's going to be in the end. And with a proper alternate perpetrator issuing a proper motive and backing it up against this evidence, the state's case is toast, in my opinion. Unless they bring out some type of BS evidence that we haven't seen yet, and I know they can't because I've seen just about everything they have, this case is toast. So we may know something on this on May 15th, but I highly doubt it. I think the defense is going to be strong enough to put it off until one of those extra hearings they've got scheduled for in July. But I wanted to go through this with you because once you start to truly understand the facts in this case, things become so much more clear. And Bryan Kohberger didn't commit the crime. Once you know that, and the evidence in the case shows that he didn't do it, then you have to open your eyes to what the evidence does show. And I gave you a pretty clear determination of what the evidence does show throughout my videos that I brought to you. Please like and subscribe to the channel. Post your comments, thoughts, criticisms. Till next time, Pavarotti's out.